Court is calling 2025 CR 004086. All right, we're back on the record. Could I have parties announced for the state? Defense.
Anita Perez for the defense.
You're charged with assault, family, household, impeding breath or sex relation, and in cause number 2025 CR 004086, you're charged with violation of bond or protective order 2 times or more within 12 months as a third degree.
The courtroom doors open, and the tension is heavy in the air. A man faces charges of assault, choking, violating bond, and pretending he didn't understand what no contact meant. His defense? Begging not to be jailed while trying to dodge accountability. This is a legal showdown with life-changing consequences, and the drama is only beginning.
Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. Plead guilty, not guilty, or no contest?
No contest.
All right. So in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates.
What those dates are referring to, which I guess we could figure out how to put in this information, were those were days that the defendant called the victim from jail. So those would be reported to jail.
All right. So
And we've been provided with those, Judge.
I'm sorry?
We've been provided those.
Well, are you stipulating that, because he pled no contest, is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024?
So as far as that, Judge, we're pleading no contest. My client has no...
Here we go. The defense lawyer thinks it's a smart move to waive the pre-sentence investigation report, basically saying we don't need the full story on a man with a record of assault and domestic violence. The argument? He's changed, he's matured. But here's the kicker. He's been calling the victim from jail, which hardly shows growth. Skipping the background check and banking on blind trust feels like a disaster waiting to happen. The real question is, how much accountability is he actually willing to take? Or is this just another excuse?
He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were 15.
Does he want to testify?
No, Judge. Let me just finish. I'm so sorry.
All right. So you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay. I'll just proceed. Right. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehement.
Now comes the sob story. The defense paints him as just a guy who's been sitting in jail for 3 months, as if that alone makes him deserving of sympathy. They point out his weight loss, over 100 pounds, but how does that excuse choking the mother of his 3 children? Now he claims he wants to turn things around, asking for probation and tossing in an I'm sorry for good measure. The defense piles on every angle: health struggles, a rough past, child custody issues, hoping to distract from the core truth. He put his hands around her neck. And that's something that can't just be brushed aside.
I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. With respects to
Now the defense brings in an Army recruiter, as if wanting to enlist suddenly proves he's turned his life around. We're asked to see him as a patriot instead of focusing on the fact that he's a domestic abuser trying to dodge real accountability. On top of that, he's pushing hard against a no-contact order with his kids, framing it as a family values issue, conveniently forgetting the part where he choked their mother. The court may be tempted by this new leaf narrative, but the red flags from his past are impossible to overlook.
The prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim...
Due to what?
The witness leaving the state.
Okay.
So as we stand here today, we have... obviously, my client hasn't had any contact with her since then. But she has been in contact with the state, which obviously, we know that is for a fact. But obviously, he's very concerned for his children. He wants to know their whereabouts, and he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is Eggerson is his last name, Sergeant Eggerson, and I did call the number. Unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally.
Well, I would ask the court to take that into consideration, that he has no legal convictions. Under any other ordinary circumstances, he has no prior offenses.
Okay, but
convictions. And so,
but if you're saying
he's a first-time offender,
all right. But if you're saying he's legally entitled to deferred adjudication on this case,
I have no statute.
Oh, right.
If the court, I have no statute. But I'm just saying, as a matter of principle, as a matter of mercy on my client, the court, I should hope.
And here comes the final act. The defense leans on the fact that he has no prior convictions, as if that magically erases the choking and repeated violations of protective orders. They push for probation, painting him as a misunderstood father trying to move forward. But the truth is clear. He doesn't grasp the seriousness of his actions. The judge isn't convinced, and rightfully so. No matter how much they dress it up as redemption, the reality is he's still a danger to those around him. His plea for mercy just doesn't hold weight.
At least because, again, he's also been in contact with being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
All right. So what I can
and
tell
they'll
you,
have to accept the transfer.
he's not a good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
in each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number 2025 CR 003.
Here's the bottom line. The defendant's plea for sympathy reads like a flimsy movie plot. He choked his partner, broke protective orders, and still argues he deserves mercy because he hasn't been convicted before. That's not how justice works. Accountability isn't optional. This isn't one slip-up. It's a clear pattern of violence. The judge saw through the defense's push for leniency, proving once again that justice isn't blind. It just refuses to be fooled.
533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in Each Cause Number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
they're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that motion.
On my behalf. Can I please speak on
I don't
my
know
behalf? I just want to testify. I didn't.
Patrick Washington.
And there it is. 4 years in prison, no contact with the victim, and a clear reminder that not every sob story ends the way the defendant hopes. He tried every excuse, every angle, but justice isn't swayed by weight loss or empty apologies. It's about the harm he caused. The real question is this: is redemption only possible when someone truly owns their actions? Or do we keep excusing people just because they know how to sound sorry?